So, without more, our random order, we'll be going in the order of Judge Jones first, Attorney Wagner second, and then Attorney Assan third. Judge.
All right. Thank you very much. Thank you to the Wisconsin Justice Initiative for hosting and putting this together, my Briesen law firm, and to all of you for showing an interest in this election. My name is Ben Jones. I'm the Dane County Circuit Court Judge for Branch 1. I was appointed by Governor Evers to take over for Susan Crawford after she was elected to the Wisconsin Supreme Court and started on the bench in August. And I'm now running for a full term in Branch 1 because, and I've been searching for a better way to say this, but I'll just say it anyway, things are a mess right now, particularly at the federal level. Democratic institutions are not operating as they have or perhaps as they should. Guardrails are being ignored and things are unsettled in the world of governance, and as that happens, courts, including state courts, become extraordinarily important. At the state level, there is a parallel system of authority that starts with the Wisconsin Constitution, and the Wisconsin Constitution is not lockstep with the U.S. Constitution. It's its own source of authority, its own source of power and rights for people. And that authority helps to protect democracy at a time when democracy is under threat. And so we need folks to be judges, to be in a position to enforce the norms and police the guardrails and to make sure that democracy is able to function and flourish. And the Wisconsin Constitution is unique in some ways compared to the federal Constitution, in that it not only does it say what government can't do, but unlike the federal Constitution, it says what the state has to do. It guarantees positive rights, rights to education. It describes voting rights, in some states environmental rights, and it functions in a way that makes the state court system, the state judiciary, extraordinarily important right now. And so when Governor Evers is faced with appointing judges to the bench, he has a group of an advisory committee that understands what's at stake when making these appointments. And that advisory committee selects folks essentially that meet three criteria. They're public servants, have an understanding of the law as I just described it, and that have the right temperament and demeanor to be a judge. And really what that temperament and demeanor comes down to is somebody who is going to be kind in the courtroom. And so my own experience, my own background, I have been a school law attorney for most of my career. I started in private practice and represented school districts primarily, along with municipalities and businesses for about 5 years. And then Donald Trump was elected, and I decided to step directly into public service and became an attorney for the Department of Public Instruction when Tony Evers was then state superintendent. I then was the general counsel for the Department of Public Instruction for Carolyn Stanford Taylor and for Dr. Underly before being appointed judge. And during that time at DPI, there were many challenges, and I had many impactful legal decisions and work, starting with when Governor Evers was state superintendent. Scott Walker and Brad Schimmel were attempting to encroach on Governor Evers' constitutional authority and to make decisions that would dictate public education. And I ended up, little old me, as a staff attorney for DPI, arguing in front of the Wisconsin Supreme Court, a conservative Wisconsin Supreme Court, and I was successful in convincing that court that Governor Evers had some constitutional authority, had the right to be in court, and had the right to defend public education. Then moving into COVID, the Department of Public Instruction, while I was general counsel, had to develop a regulatory system on the fly to both keep people safe and to keep education open and educating kids. And that led into the Trump administration demanding that the Department of Public Instruction abandon any efforts to narrow the racial disparity in education in this state, to completely ignore the historical context of race in the state in order to receive any federal funding. And I orchestrated the legal strategy to respond to that threat, understanding that it wasn't going to take a legal argument to convince the administration, because the legal administration has indicated again and again that they are less likely to be convinced by the rule of law. So instead, we pulled the conversation into the public and said, please, Trump administration, tell us why you're doing this, what legal authority you're relying on, and why you think this is a good idea for Wisconsin. And never heard a peep, but they backed down. And since becoming a judge, I do feel some guilt for not staying in the fight at the DPI, but I think right now I am in a good position to do the kinds of things, make the kinds of decisions, relying on my background and understanding of constitutional law, separation of powers, and then all of the little things that go into being a general counsel for a large institution, contract law, prosecuting teacher licenses, navigating employment issues, all the things that a general counsel has to understand and be quick to understand and apply, have really provided a nice foundation for me in my transition to becoming a judge. And when it comes to that third component, the temperament and demeanor, I could sit up here and talk about how nice of a guy I am, and that would be extraordinarily uncomfortable for me, and I'm not sure I would convince any of you. And so for that third part, I'm really relying on the endorsements of all of the people that have gotten to know me while transitioning to be a judge throughout my career. Some supporters are here in this room, but you know, I had the opportunity to learn from Justice Crawford in my transition to the bench. She has now endorsed me and is a supporter of me, and not just for this campaign, but it really gives me the confidence to know that I am the right person in this position at this time, and gives me confidence to know that I'll be a good judge for another 6 years. Thank you.
Hi, my name is Nathan Wagner. I would like to thank our hosts, and I will talk a little bit about my background. I went to law school, let's say, later. Prior to going to law school, I spent 4 years in the Army right out of high school, and I had a career, or at least half of a career, I guess, about 10 years, 10 or 12, doing computer consulting for various companies around the country, including one contract actually in Calgary, Canada, and that was a difficult career in terms of the sorts of skills that you have to do, both contracting, traveling around, meeting all kinds of different people, plus the, intellectual needs of dealing with the computers, which, as I'm sure everyone knows, can be fussy. And so, and then later, about 34, I decided to go to law school. And I went to law school and graduated then when I was 37. I opened a practice in Texas because we wanted to move to Texas at the time. And so I took the Texas bar. I practiced there for a couple of years, but then I got roped back into doing computer work because I had 10 years of experience doing that, and the offer was too good. We eventually moved back to Wisconsin in 2014, and we've been here ever since. I did computer work again for a little while, but for the last several years, I have been a practicing attorney here in Wisconsin. And that includes family law, small business law, and the sorts of things where I routinely encounter and work with and try to help actual people with local problems and help them navigate the court system. For everyone that's walking into the court with or without an attorney, they all have a reason why they're there. They have some legal difficulty that is special to them, not necessarily fitting into the grand scheme of things that may be going wrong in the large. And I think that what I try to help them with is not trying to fit their problems into solving the world's problems, but rather seeing what I can do within the scope of what we do to help them resolve their problems. And I think as a judge, that is what I would bring to being a judge, and understanding that my role is not to see how their case can be fit into advocating for or against some large position or some global problem, because all of those people deserve a judge who is looking at their problem and how the law applies to their problem and how the facts fit into the law for their individual case. And I think, and one of the reasons that I'm running is I have seen, I think, perhaps a pull towards everyone trying to solve the world's problems, sometimes to the detriment of helping the people that are actually there, you know, worrying about, are they going to lose their business or their kids or their savings? And those are the real concerns that I would look to as judge, always keeping in mind. And I think my background of doing more than just going to law school, being an attorney, working as an attorney, you know, either directly with clients, public service, and so forth, I think that additional experience that I have would really help me stay grounded in that, you know, I have perhaps been in maybe not the exact shoes, but, you know, some of the similar shoes that the people that would come in front of me in court may have. And I think it is those strengths that would make me a good judge, and it's why I wanted to run and am running, and hope that people will vote for me. Thank you.
Hello, I'm Huma Assan, and I just wanted to thank everyone. I wanted to thank Von Briesen, and I wanted to thank the Wisconsin Justice Initiative for having us here and giving us the opportunity to speak a little bit about who we are and why we're running. And I said, my name is Huma Assan, and I'm running for Dane County Circuit Court Judge, Branch 1, and I'm running to bring my depth and my breadth of over 25 years of legal experience and life experience to the bench. For me, as a mother of 3, this campaign isn't about titles or ambitions. It's not about appointments or endorsements. I'll be honest, a year ago today, I wasn't planning on running for anything. I was a practicing attorney, just minding my business. So how did I get here? On the day of the No Kings rally, I was asked to be a featured speaker by Voices de la Frontera and Indivisible, because I had been an immigration attorney in town for more than 15 years. And on that day, when I gave my speech in front of 15,000 people, it was so inspiring to look out at that crowd and see all walks of life in Dane County that day, united in saying that what's happening in our country isn't right. Due process is for everyone. Our fundamental rights are not negotiable. And it's one thing to believe that others feel the way you do, and it's another to see it, to hear it, to be part of that energy. And after that rally, I realized I couldn't sit by. I had to act. And at that moment, that sparked this grassroots efforts of this judicial campaign. This is a judicial campaign to be a judge for all people in Dane County. I'm running because I believe our local courts have never been more important. I'm running to protect our judicial system for all of us in this little part of the world. I'm running to protect Dane County's ongoing commitment to be a welcoming community where everyone belongs and everyone is seen and heard. I'm running to ensure the law serves all the people, regardless of where they come from, how much they earn, or what languages they speak. And my story, like many, it didn't begin in a courtroom. It begins in a living room in a small town where being an immigrant is often being meant to be invisible. Both of my parents immigrated to the United States in the 1960s, and I sponsored my immigrant husband in 2000. So I know what it's like to be the only immigrant child in a classroom, to be your parents' interpreter, to be the bridge between two languages, two cultures, and to carry the weight of that burden and responsibility. But more than anything, I know what it feels like to feel afraid, to feel like the other, to live in a country that you love, but you're never quite sure that you're safe in it. My father came to this country as an international student, and he did his PhD and worked for NASA. He became a professor at Western Kentucky University and UW-Stevens Point. My mother joined him later, but unlike my father, she didn't speak English. She learned English at the tech school at Stevens Point. They lived behind the Piggly Wiggly there. And when she arrived, she carried something more powerful. Her grit, her grace, and the courage to belong to a country that didn't always welcome her. She wasn't handed power. She earned her place with quiet strength and relentless hope. And that same fire, that same resolve, it lives in me and it lives in the communities that I serve. Since 2005, I've called Dane County home. And as I said, for over 25 years, I've dedicated my legal career to fighting for those that are unseen, unheard, and too often forgotten by the justice system. As an immigration attorney and founder of Madison Immigration Law, as a former Chief Justice of the Turtle Mountain Court of Appeals, who rebuilt that court system after a devastating fire destroyed the court system and the federal government was threatening to take that court system over. As a legislative attorney for Ho-Chunk Nation, as the deputy director for the Great Lakes Indian Law Center at the University of Wisconsin Law School, and at the beginning of my career as a legal aid attorney serving rural and indigenous communities. I've fought and fighting for people who are unhoused, domestic violence victims, and veterans. In every role, I have fought not just for justice, but for visibility, for people who have been told that they don't count and their voices don't matter. And maybe we think Dane County is safe from disparity, but right here in Dane County, only our domestic violence protection orders, restraining orders, they're only issued 34% of the time. And at the same time, arrest rates for African Americans are 11 times higher than that of whites, twice the average of the national, twice the rate of the national average. Even though these higher rates happen, our African American population is only 6% of the population. And while we love Dane County, it's clear we have work to do. And it's clear we have work to do for everyone to be seen and to be heard, and for everyone's due process rights and fundamental rights to matter. And as we're seeing on the national stage, rights taken away from one can be taken away from all of us. Folks, we are living through a time of rising fear, polarization, and uncertainty. Across this country and in federal courts and state legislatures, we've seen rights stripped away, protections weakened, people targeted, simply for being who they are. And we can't be naive. Our Supreme Court and federal courts are no longer neutral ground. They are battlegrounds where many are fighting not just for justice, but for their right to exist.
Attorney?
And here
Attorney?
in Dane County,
Attorney?
Yep. Okay. I'll just say that we have to hold the line. And I'm just going to say that I'm just asking for your vote on February 17th and April 7th. And I'm asking not only for your vote, but for your voice. So if you believe in me and people like me, people who have fought for visibility and inclusion throughout our justice system, today I'm asking you as lawyers and professionals to believe in what's possible, to believe in courts that protect, not persecute, and local justice that stands strong against federal fear. You can join me, join humaforjudge.com. You can look us up, make phone calls, help us build a grassroots campaign powered by hope, courage, and the unshakable belief that every person matters in Dane County. Thank you.
All right, we've heard from the candidates. Time for questions.
What can you do and what will you do if ICE or CBP shows up approaching your courtroom and you suspect that they're looking for one of the parties in your court, or a witness, or an attorney, or just a visitor to the courtroom? And what sort of evidence of that person will you demand if they are in your courtroom?
And we'll proceed in the same order, so Judge will, it turns out, we'll come right down the road.
Yeah, I'm going to stand because I got to see the folks in the back. This is a question that's on every judge's mind, I think, in Wisconsin. I would imagine it's a matter of when, not if. As a judge, I have control over my courtroom, and I have the ability to police who is able to enter and exit, and if there's a disruption of any kind, then I have the ability to police that courtroom. Outside of the courtroom is a much more difficult question, and our bailiffs are set up to engage with law enforcement, and there are policies and procedures in place for how that is meant to occur. But there are other ways that ultimately it's a question of are folks having access to justice? Because I think it is an extraordinarily dangerous and difficult situation where somebody has to debate whether to come and be a witness in a criminal trial, or whether to gain access to a family court, or whether to participate or have access to justice at all. And to have that threat looming over somebody is terrible. And so in small ways, I can reach outside of the courtroom. Zoom, of all things, is a useful tool to say, Your Honor, I don't feel comfortable coming into the courtroom. Can I appear virtually? Yes, you may. I mean, there are circumstances, and I might want to explore why, but that is a simple and useful tool to say, we're going to remove physical proximity as an issue for your access to justice or your contribution to justice. Scheduling things, but ultimately, there's going to need to be something beyond the courthouse that will change how immigrants are treated in this country, and I think you're seeing that in Minnesota. But in my ability to police the courthouse, I will do what I can with the tools that are available to me to make sure that people aren't afraid to come into the courtroom.
To answer the specific question asked, which is what would I do if ICE were in the courtroom, would really depend on what we were doing at the moment. I would not expect, for instance, if we were in the middle of a hearing and taking testimony, for them to barge in, and if so, if that were to happen, there are bailiffs and other, sheriff's individuals and that can be brought in to resolve that issue. That is, in some sense, largely the same, though, as to any actual immediate disruption to the proceedings of the court. If it were slightly more general, I'm not, as a judge, generally going to be deciding on the validity of, say, a federal arrest warrant, but I would direct them to go to the bailiffs and request the assistance of the local law enforcement. I mean, the sheriff is generally in charge of security of the courtroom, and I don't see any reason why I could not request and require that ICE look to cooperate with the sheriffs in executing any of those warrants.
2 minutes?
3. Yep, a maximum of 3.
I'm gonna talk fast, okay? First off, we need to know that ICE doesn't use judicial warrants in the way that we think of them. They can come in, they have these things called administrative warrants, where they write up pieces of paper that say, I'm gonna use you, Nate, that I am here to arrest Nathan Wagner, because I am an ICE agent, okay? And when they present to the courts, sometimes they say, they even say this to immigrants, immigrants say, do you have a warrant? They say, yes. They open the door, the immigrant opens the door, and then they proceed into that, okay? That isn't gonna happen in my courtroom, okay? I think we need to have procedures. I have argued for a Wisconsin Supreme Court rule banning ICE in any courtroom unless they are able to show a judicial warrant signed by a judge. That still would have to be an argument for the Wisconsin Supreme Court. But in my courtroom, I think, like if we look at what justice, we'll just take the case of Justice Dugan, all right? All of that transaction happened outside the court, okay? What we need to actually have happen is that we need to put them on the record. As the trial court, we are the trier of fact. So when an ICE agent comes into the courtroom, if they're masked, we need to have that on the court that there will be no, if you appear before a court and you are a law enforcement, you will state your name, your identity, your badge number, your address, and you will be unmasked in my courtroom. That will be what I would require to be on the record. And if they have a objection to that, we will take it on the record, okay? And then safety is very important for all people who are appearing in my courtroom for both parties. So yes, we can use Zoom if possible, but procedurally, that's what needs to happen. We need to create procedures for when this happens, okay? Procedures for how we're gonna do it, and also, since we are Dane County with the trier of fact, it has to be on the record so that if something happens, it is an appealable issue and it goes up to the Court of Appeals, the Supreme Court, Wisconsin Supreme Court, because then once we have it on the record, then we can be talking about, did the federal ICE agents obstruct Wisconsin law versus, Sarah Dugan obstructing federal law? There is an argument to be made whether or not, if an ICE agent comes into a Wisconsin courtroom, whether or not that is obstruction of Wisconsin law. That's what I can say.
Thank you. That's time. All right, another question.
Can you speak to the subject matter that most of the circuit court cases typically are, and what your relevant experience, what areas of experience you have?
Assuming we're doing the same order.
Sure.
Same order.
So right now, branch 1 is in a civil rotation. And what that means is that it describes the cases that come into the court. So it's everything but juvenile or criminal cases are what are taken into the court. Family law, contract disputes, business disputes, personal injury, any of those kinds of disputes. And so right now. I've been doing it for a number of months is my first direct qualification, but I also started my practice as a civil attorney in private practice, again representing municipalities and school districts and some businesses, and then going into the Department of Public Instruction, as I described, as a general counsel. If anybody's ever practiced as an in-house counsel for a large institution, you're a jack of all trades, particularly in the civil arena, handling all legal matters that come into the institution, if not acting as second chair in litigation, or in my case, advising the Department of Justice and working on discovery issues and working on litigation as the agency attorney. And so the only experience that I didn't directly practice in would be in family law, but I have now had the opportunity to go through Judicial College, to talk to my colleagues at Dane County, who have been very supportive in getting me up to speed on the issues of family law. I think there are some family law attorneys in here that have appeared in front of me. I've had several family trials at this point, and so all of that is to say, I've been tested in all areas of the law that come before Branch 1 as the Branch 1 judge, and I'll leave it to others who have endorsed me to speak on behalf of how I've handled those matters. Thank you.
My law practice is mostly family law and small business law with some small business litigation. So I have routinely appeared in court on the at the table, and I have reasonably large amounts of experience acting as counsel or attorney for parties in court. I have recently, in anticipation of being elected, taken some criminal cases through the State Public Defender's Office Assigned Counsel Division, because I did not, as part of my normal practice prior to running, had not done criminal law, and despite having experience other than being a judge, none of that was being in criminal court myself, so I wanted to expand on that. And so with that experience, both that I'm getting now and with my litigation background, both family law and small businesses, I think that gives me a breadth of experience that I will hopefully have at least some familiarity then with any type of case that might come in front of me as a judge.
I have a vast depth of experience. I bring over 2 decades of serving real people in the community. I believe I'm the only candidate that can say I bring 25 years of legal experience to the bench. It spans from my time at Legal Aid, when I represented, as I said, unhoused people. I represented people. I believe I'm the only candidate up here that has represented survivors of domestic violence, particularly. That is in divorce, custody, protection orders. I feel like I'm the only candidate here that has secured significant federal funding through the VAWA grant to provide for legal aid, over $85,000 in legal aid funding for protection orders for rural and indigenous people, particularly women. As I said, I worked at Legal Aid, and when I was there, I was the chief attorney there, and we had one of the cases was the Minot mobile home case, where there was a company that bought up 3 of the 5 mobile home parks, and they jacked up the rents and the deposits. So I went around and I collected all of the signatures of all the different people, And legal aid eventually ended up suing them, and we formed the Minot Mobile Home Association to do that, and that led to statutory changes. Here in Wisconsin, I was the deputy director of the Great Lakes Indian Law Center, where we worked with tribal court initiatives to strengthen tribal courts here in the state. I appeared in front of the late Shirley Abrahamson and to develop a rule of court called the full faith and credit that provides full faith and credit of tribal court orders that would be equivalent to state. So those of you that don't know, in tribal courts, they do almost some of the same things. You can get a divorce order, a custody order, a protection order, criminal issues. We've had PI issues. So besides that, I think I'm the only one here with significant judicial experience. Prior to this date, I was the Chief Justice of the Turtle Mountain Court of Appeals, where I talked about that courthouse burned down to the ground and I had to rebuild it. I had to hire judges, create court budgets, reconstruct court proceedings, conduct oral arguments. And then I also expanded transparency of that court because we put all of those court orders online and we work with the community college. So I have about 50 published opinions. You can go to Turtle Mountain Community College to check out my opinions. Some of them appear in federal Indian law textbooks. And besides that, last summer I was accepted
Attorney,
as the Emerge Gavel In
time.
program, and I believe I'm ready to lead the court with those 25 years. Thank you so much.
Next question, please.
Can you give an example of a decision you made that might not align with your personal political beliefs or ideology, but that you felt was a correct application of law? And for any candidate that has not made judicial decisions, can you identify a law that maybe you personally disagree with, but would nonetheless faithfully apply?
I'm going to cheat a little bit with my answer. There is an area of law that I haven't practiced in that has come up in my court, which is the reverse waiver process, which is when a juvenile is charged with a certain crime that gives original jurisdiction to adult court, so homicide, for example. And there's a process where that child has the opportunity to argue back into the juvenile court. And making that decision, there are statutory factors that are defined for me and for the court. And it's a struggle because when looking at those factors, they seem constrained to me. They seem to exclude a significant amount of context that would make a good decision in that context. And I'm cheating because while that decision is pending, District 1 Court of Appeals has issued a decision stating that the reverse waiver statute is unconstitutional. Because exactly what was going on in my mind, that the factors that the legislature has handed down are too constrained. It excludes much of the context that the Constitution requires you look at to apply due process. And so I say that for two reasons. One, in response to your question, I was prepared to give a decision that was contrary to what I thought was the right thing, because I am an impartial judicial officer. I am there to apply the law to the facts, and if it comes out in a way that I don't agree with, so be it. That is what the law is meant to be there. But second, I was glad to have some reinforcement that my instincts as a judge, at least when it comes to the First District Court of Appeals, are not off the mark. That I was not the only one in the world that thought this reverse waiver process maybe requires more when deciding the future of a child that may be convicted and imprisoned for 20 years versus rehabilitated as a juvenile and have the potential to live a productive life.
I obviously can't talk about any specific cases that I may have had, but I don't, when I'm looking over a client, either a new client or any client, I guess perhaps my brain just falls into the, oh, this is a problem, you know, that has some sort of logical application. I don't normally even think about what my personal opinions on the law might be. First and foremost, because those are irrelevant to helping the client. The client is, you know, there are lots of laws I don't like. One of the things that I hate having to tell a client is that you seem like you were wronged in some way, but you don't have any legal remedy here. Or sometimes, you know, it can even cut the other way, which is, I do have the discretion as a private attorney that I wouldn't have a judge, as to sometimes I don't have to take a client. But there are cases where if the client's coming in with a consult, or if something develops after the client has hired me, where it comes into, yeah, you're probably going to be able to win on this, and boy, I hate that. I mean, obviously I'm there to advocate for my clients, and I do. But that doesn't mean that I always like that result. But my job, both as an attorney and as a judge, is not, I really don't, it doesn't even cross my mind when I'm working on the things, because the problem of, you know, the grappling, the mental problem of, oh, how does this law apply to here? Or is there something that, oh, maybe I can make an argument to get out of it, or reading cases to see if perhaps I can somehow distinguish this from the other case. And I guess I get so wrapped up in that I don't even think of that as a practicing attorney. And certainly as a judge, you don't want me to be bringing any political beliefs that I may have in, not least simply because you don't want what outcome you get to be a crapshoot on, did you get the lucky judge? You know, you want a certain consistency among judges, and a lot of those things that I might not like are really going to have to come from the legislature in terms of actually changing those. I mean, as a judge, there's a certain amount of, you are constrained a bit by what is handed to you, both in terms of facts and the law, but I would certainly just look to see how those apply, and that's certainly what I do in my practice, and continue to do so.
Yes, well, the only time that I can honestly say that I have agreed with an adversarial decision, I've gotten many, you know, doing domestic violence work and legal aid as well. But it is important, I do agree that there are times that, there's a lot of times, you know, especially in domestic violence, that the opposite side, you know, the person who is being alleged to have, you know, committed the violence against the person, you know, they should be, have an opportunity to be heard. There should be standards. There is a standard to, in ordering domestic violence protection orders or restraining orders is typically, in most states, it's some sort of immediate threat of physical harm is what the standard typically is. So that's what has to be proven by the petitioner. So it, you know, there are many times that I have, when I have been arguing as an attorney for someone who may have been, had this committed, but they weren't able to prove it. So it's absolutely necessary to make sure that the system works for both parties.
I think we have time probably for one more question.
Right up front.
So all of you have spoken about upholding the law and sort of following the facts of the case, but how much judicial discretion do you have at the circuit level? You know, things like what evidence to let in, what evidence not to, what evidence to exclude, and what would that mean for somebody sitting in our position looking to vote for or the next best candidate?
Right, yeah, there's discretion exercised in the courtroom every day. And so for those in the back that may not have heard, I think the question is what does the exercise of discretion as a judge mean for the people of Dane County who are going to be voting? And there are so many little decisions in a given day and a given hearing that add up to a body of work that all judges are trying to strive for justice. It's a mishmash of words that basically means we're the trier of fact, we're the fact finders, we build the record. The Court of Appeals is stuck with the record that we give them. The Supreme Court is stuck with the record we give them. And so those discretionary decisions go toward shaping the questions that are going to be presented to the Court of Appeals. And also, they go toward the decision, the ultimate decision of people who might be there at the lowest moment of their lives, the most important part of their lives. All those little discretionary decisions add up. And so I think I want to answer your question by talking about judicial philosophy. So in what's guiding me when making those discretionary decisions. And that comes down to what I talked about before with temperament. What am I there for? How am I treating folks? And what am I trying to convey to them and learn from litigants? And it's very important to be empathetic, but really to understand the entire context that applies to a particular decision. And so when faced with a discretionary decision of, do I exclude potentially relevant evidence because I want to get out to lunch and have a relaxing time? Or do I want to take the time, this person has come to court, has paid a fee, has a problem that they have had to take a full day, probably multiple days to come and try to resolve? You should take the time as a judge and exercise your discretion to listen to everything that you that is relevant toward making that decision. And so that exercise of discretion shows up in those tiny little moments of, well, Your Honor, I have one more question. And instead of saying, nope, we're done, you can say, all right, here's what this law means, here's what I'm trying to apply, here's what I'm trying to describe. And that's particularly true when it comes to pro se litigants. So pro se litigants who don't have an attorney who can give you the play-by-play after a hearing is over to say, okay, here's what actually happened, or here's why the judge did something. Somebody who is pro se is going to come in front of a judge and be totally scared, totally overwhelmed, but still wanting to tell that story, wanting to have access to justice. And so those moments are incredibly important for me as a judge to exercise my discretion and not just say, hey, I'm going to ask you some questions and then something's going to happen.
It's time, Judge.
But to really take the time so that people know why they're there, that I've heard them, and that I'm making the best decision that I can.
Appeals are constantly reviewed for abuse of discretion by a judge. And I think that when making all of those decisions that you do have discretion over, not just what evidence might come in, but even how long someone might be able to speak, or anything else, that all of just the minutiae, because the rules of procedure, criminal, civil, cannot cover every single possible thing. Every case is unique, and so every case is going to need someone to make a judgment call as to how those different small decisions, or sometimes large decisions, if it's suppressing of evidence of any kind may be. So I think my take on that, but in making those decisions, is we're all trying to get not just a legally correct result, which we would like to get, but we would also like to get a result that people think is fair and just, possibly even if they didn't go the way that they wanted it to go. I have been, I have had a judge rule against me, and I'm thinking about it in the background. I was like, yeah, I probably would have ruled that way too if it were my choice. But you want that result to be fair. And so I will try to always have in the back of my mind when exercising the discretion the judge will have to is this choice one way or the other going to help us get a result that isn't just legally correct, but also one that hopefully everyone can live with and is comfortable with, like, yes, that made some sense, even if you didn't go to law school.
Yeah, I happen to agree with a lot of what my colleagues talked about. You know, fairness is the cornerstone of the profession, you know, and a part of that is the judicial discretion. As we talked about earlier, you know, this is going to be, the trial court is the trier of fact, you know, so whatever is the record, you know, as everyone said, we are stuck with it, you know, whatever you're making the reporting and the trying of fact, or what will be an appeal or appeal that could go on to the circuit court, or the Court of Appeals or the Supreme Court. But at the end of the day, it is important that each side is heard and listened to. I think that's a very key point in this, and I would use my discretion in making sure that both sides are given that opportunity to be heard and to be listened to, and that their cases are thoughtfully looked at, and that we look at the fact finding and make sure that our record is fully encompassing both sides. That's the discretion that I would use.
We're pretty close to 1, and while we haven't set up on the agenda a final statement, I think it might be appropriate to give the candidates 30 seconds or so and juggle up the randomness of this a little bit.
It's going to be the same.
It's gonna be the same. So far. All right. First, second, third. Let's see if you can hold it to about 30 seconds.
30 seconds.
We'll take 45.
Sure. Well, ultimately, the job of a judge is to impartially decide cases without prejudice or bias. I just want to say a note about what's happening in the world, because as a judge, I also have eyes and a brain and ears and can see people a disrespect for the rule of law. And I just want to take the opportunity to ask all of you, if you haven't already, to take a look at what federal judges at the district court level are writing about this administration and what's happening in the world, because it is incredible, and it's worthy of study and attention, and if nothing else, I just want to take my 45 seconds to say this is an unprecedented time, and we need folks in positions of authority who are equipped and able to take that on. I think that's me, and I think the Governor's Advisory Committee and Justice Crawford and the folks that have endorsed me and are supporting me and the folks that I've learned from all agree that I am the right person for this time to be judge in branch 1. So thank you.
Precedent has been set, 1.5 minutes.
Ready? Yes. Well, just in closing, I think I'm the right person for the right time with the right background. I am the only candidate that brings the 25 years of my legal experience to the bench. I'm the only one who's created a law firm here in Madison. I'm the only one with immigration experience, and I'm the only one not connected to anyone in government. And I'm the only one who I believe that is endorsed by, we'll see, the 15,000 people that were out there at the No Kings rally. And I stand here not connected to any government official or any endorsed official. Probably none of you are endorsing me, which is fine. because I am running to be the people's judge. I am running to defend that our court system should belong to the people, not to government powers, to the people. All judges are elected in the state of Wisconsin, and they're not elected by government officials, they're elected by the people. And that's exactly what this campaign is about. So if you want your judge elected by the people and that come from the people, then I think I'm your candidate. I bring 25 years of experience. I'm the only one who comes from the Dane County Bar Association and has gone through the Emerge Gavel In national program to be trained as a judge. I'm the only one that brings significant legal judicial experience to the bench with published opinions and has worked at the law school and has developed my own firm. And I'm in this not because I have to, but because I'm in it for the people. Thanks.
Attorney.
Thank you. I'd like to thank everyone for listening to my answers. I hope you like what you heard. I would like to be able to take my experience and my judicial temperament, I hope, and hopefully your votes, and help these people and serve the people of Dane County as a judge. Thank you.
Good. Well, thank you to all of you. And that concludes the event. Thanks for attending, everybody. We appreciate it greatly.